everyone for coming along. It's a great pleasure to have Christopher Rennie-Smith with us this evening. He has been a long-serving member of the European Patent Office Boards of Appeal, and before that was a member of this university. He studied law and practiced in several firms in London, taught at the University of Sheffield, and has been involved in patent law for a long time. So thank you. He's going to talk about an insider's intake on the industrial applicability requirement. Sorry about the screen.
I think it's good. When you reach my age, you know how that feels. Well, thank you very much for your introduction. Thank you for inviting me. I did start my legal career at Cambridge. Someone just asked me how long ago it was. The answer is at least 40 years, I think. So, I want to talk today about industrial applicability for two reasons. It's a nice, small, self-contained subject, and it also offers a good example of the interplay between European patent law, the law that we operate under the European Patent Convention, and the national courts, and as it happens in this case, the courts of our country. And before I get into the law, such law as there is, I just want to mention a couple of cases which offer background as to the relationship, this interplay between the Boards of Appeal and the national courts. In Actavis and Merck, a case decided in 2008, Lord Justice Jacob, as he then was is the most used expression in appellate judicial circles. You use it every 2 or 3 lines. Lord Justice Jacob, as he then was, picked up on a point made by a lawyer appearing in front of him, which he said had been put so colourfully in the skeleton argument he wanted to repeat it. And it went as this: you cannot have 34, which was then the current number of European Patent Convention states, 34 ships steering the same convoy, unless there is something like a Commodore. That's why the Court of Appeal in Genentech, in 1989, referred to the Board of Appeal of the EPO as the central decision-making body of the European patent system, which must be hearkened to with particular attention. In saying our courts would and should normally follow the settled jurisprudence of the EPO, it should of course be understood they are not bound to do so. In the unlikely event we are convinced the Commodore is steering the convoy towards the rocks, we can steer our ship away. Technically, we're not in the same position as we are in the case of decisions of the European Court of Justice, something we'll come back to later. And of course, if there is no clear message from the Commodore, or he gives us mixed messages, we must decide our own course anyway. And then just briefly mention that the same person, Mr. Justice Jacob, as he then was, in 1997, said in Lensing's case, you remember Lensing is the case where a disappointed party in the Boards of Appeal tried to convince the British courts that the Boards of Appeal were not independent and were not operating judicially, and so their decisions could be quashed. Mr. Justice Jacob, as he then was, said the United Kingdom and other member states have agreed at an international level via the EPC that the Board of Appeal is the final arbiter of oppositions. It is the agreed EPO equivalent of the House of Lords, the Cour de Cassation, or the Bundesgerichtshof. The Boards of Appeal do provide judicial review within Article 32 of TRIPS. Although it's strictly a matter of purely international law, I also conclude there is no doubt whatsoever that the European Court of Justice would also so find. The point is acte clair. So I set that as the scene for what we'll see later on when Board of Appeal case jurisprudence gets looked at by, in fact, 3 levels, 3 instances of the national courts in this country. But first, a little background on industrial applicability. One of my colleagues in Munich has cut out and put on the wall outside his door a cartoon which shows left foreground a caveman in skins and furs and so on, with a big circular stone disc coming up to about his thigh beside him. And he's pointing very angrily to another caveman coming out of a cave, left background. Did I say left? Right background. Who's wheeling a similar stone out in front of him. And the first one says very angrily, "Hey, that's my intellectual property." He actually says it in German, but we all know cavemen didn't speak German. Now, if the caveman had gone to the Neanderthal patent office, this being the first ever wheel, which nobody had ever heard of, the examiner would have said, "So what does it do?" And if the caveman had said, "Well, if you take two of them and attach them to a platform or a box, you've got something called a cart. Ah, you can use it in transport." That's industrial applicability. Until we got the biotech cases relatively recently, that's what industrial applicability was about. Can you use it in an industry? And the EPC's legislation is very straightforward. It says that an invention to be patentable must be novel, have an inventive step, and be susceptible of industrial application. The English law says capable of industrial application, but that's the same. And Article 57 elaborates that by saying it's susceptible of industrial application if it can be made or used in any kind of industry, including agriculture. Fine. It's usually really, I didn't mean to say that. Really. It is usually very, very obvious what the application is. Rule 42 says that if it's not obvious from the description or from the nature of the invention, then you need to indicate explicitly what it is. But the vast majority of inventions do not need that explanation. Any product can be bought or sold. It's industrially applicable. Any piece of machinery can be used. It's industrially applicable. Any part, any tool, any method of operating something can be industrially applicable. You don't need to say it. All the case law before the biotech cases was really just putting the very boundaries to what was or was not industrially applicable, to what industry was really. I'll give you a few examples briefly. T144 of 83, they're on the list and you don't need to worry about them. You can look them up if you want. But the question was whether using cosmetics in a beauty parlour was use in industry. And the Board of Appeal said, yeah, of course it is. So somebody's doing something for commercial gain. They're going to make a profit out of it. That's industry. End of story. Nudging slightly closer to the biotech cases, T606 of 96 involved a method and a kit for cancer diagnosis. What was required was to make up, as I understand it, per case, per treatment, what was called a cocktail of antibodies in order to perform some diagnosis. And the opponent there said, well, who had set up a manufacturing plant to do sort of one-off cocktails of drug compositions? And the board said, no, you're just looking at it the wrong way. What happens here, for example, you could have diagnoses made in hospital laboratories. They don't have to make a profit, but they're involved in a commercial activity in as much as they have a throughput of patients who are treated and money will change hands at some point in the system. That's okay. That's industrially applicable. That's perfectly acceptable. The only limitation in the old law really was the bedroom door. In T74 of 93, this involved a method of using a contraceptive. Not the contraceptive. Contraceptives are industrially applicable. You can buy and sell them. Been able to for centuries. But a method of using a contraceptive. It was actually a contraceptive cream to be used by ladies. And the board said rather primly this only happens in the purely private and personal sphere. And so we're not going to say that's industrially applicable. There were some rather questionable arguments about possible use in prostitution, which the applicant said is the oldest, the oldest profession, etc. But that didn't wash. 1165 of 97, however, said that the use of something called a vaginal discharge collector, I don't propose to go into any more detail, not that I know it, was a method for using that device, even though obviously you would probably do it in your bedroom, not anywhere else, was industrially applicable because this would be brought to the user by some professional or para-professional who would have instructions from someone else how to use it, or instructions which came with the device. And it would then be taken away and the samples collected could be used for various forms of diagnosis, a bit like the cancer testing case. So, yeah, truly private, but that was right at the edge. You had to go all that way, to the bedroom door, as it were, to get to the edge of industry. Another type of case which sometimes invoked Article 57 was the so-called revolutionary inventions. Not as many, actually, as one might think. I only know of a few. T184206 is typical because that's one of several applications for patents which involved the inventions, if that's the right word, of the Frenchman Jacques Béveniste, who coined the memory of water idea. Have any of you come across this? Well, don't ask me to explain it, because he couldn't explain it, or they couldn't explain it adequately to get a patent. The reason I mention 184206 is because, like some other cases, it illustrates the fact that really, when you get to this point, beyond the laws of physics, beyond the known laws of science, it doesn't really matter what you fault the case with. You can fault it on inventive step because there isn't an inventive step. You can fault it on insufficiency because you can't work it. And indeed, 184206 is one of the cases which says that the test for industrial applicability is really the same as the test for sufficiency. The evidential test is the same. And the evidential test for sufficiency comes from T1990, which is the first Oncomouse case, which you probably have heard of, even if you haven't heard of some of the others I've been mentioning. And that said, the test is that you have to have serious doubt substantiated by verifiable facts. So you get to the point on the classic law, or the classic case law, such as there is of it, of industrial applicability, that you don't have to mention it if it's not obvious, and if there's any doubt, you simply have to show what it is. And industry can be almost anything, up to the most private part of the home. And that the burden is on somebody else to show some serious doubts backed up by some facts if you want to dislodge it. So not many cases really fell foul of industrial applicability until we got to biotech. Now biotech, the law doesn't change much when we come to the biotech cases. The only additional piece of legislation is Rule 29.3 of the Convention, and that comes straight out of the Biotech Directive. And Rule 29.3 says the industrial application of a sequence or a partial sequence of a gene must be disclosed in the patent application. So there is a rule which says you must put something in the application, whereas for other cases it simply says if it's not obvious you must. And I think that, in a way, summarizes the difference between the classic cases and the industrial applicability cases we're going to look at now. Let me start, if I may, by describing the patent in the case which has given rise to all the excitement. Well, the case says it's the Nutrikine Alpha litigation, which was conducted both in Munich before the Boards of Appeal and here before our courts. In the Supreme Court decision in Nutrikine Alpha, Lord Neuberger, who I gather was here last night and probably gave a more interesting talk than you're listening to now, but anyway, Lord Neuberger said the patent describes the encoding nucleotide, the amino acid sequence and certain antibodies of a novel human protein which it calls Nutrikine Alpha, and includes contentions as to its biological properties, as well as those of its antibodies. These contentions are predictions, substantially based on the proposition that neutrokine alpha is a member of the TNF ligand superfamily. The specification or description of the patent is confusingly long and widely expressed, running to over 25 closely typed pages and nearly 200 paragraphs of descriptive text, and a further 12 pages of polypeptide amino acids and DNA nucleotides. As Mr. Justice Kitchen, the first instance judge, said, the specification contains extravagant and sometimes contradictory claims, claims in the sense of assertions, not patent claims. Perhaps rather more tolerantly, the Technical Board of Appeal of the EPO referred to the patent as having been drafted on a boilerplate basis, which it described as a practice used by patentees. Just park that in your memory for a second. We'll come back to that in a minute. He then takes 2 paragraphs explaining what the specification says about the new protein. And then he goes on to talk about the treatments it purports to have some significance for. The specification then describes the claimed invention as potentially useful for the diagnosis, prevention or treatment of an extraordinarily large and disparate number of sometimes widely expressed categories of disorders of the immune system and other conditions and actions, either through the protein itself or through its antagonists. However, nowhere in the patent is there any data or any suggestion of in vitro or in vivo studies, so there is no experimental evidence to support any of those suggestions. If you look at the patent, or if you look at the first instance decision, the judgment of Mr. Justice Kitchen, as he then was, you'll see that he occupies some 2 pages in reciting the list of conditions and diseases and treatments which this protein might have been potentially useful in treating. And that's typical of the cases that we get in this field. You have a new discovery, a new protein, a newly engineered molecule. It has the potential to do all sorts of things, but companies being companies, they rush off to the patent office before they have any proof that it actually does any of this. And the classic question is, are you giving them a patent for something new, something which is there, which is industrially applicable, or are you giving them a patent to carry on research? Are you giving them a patent for a research program, which means they can research and others can't? And that if they get there first, then they will have a much bigger lead over the others, and they will deny others the right even to conduct research, even to join the race. I'm not going to take you through all the case law of the Boards of Appeal prior to neutrokine, because there's too much of it. It's all summarized in the article of a gentleman called Ertz, which is on the handout, summarized as of the date he wrote that article, which is 2008, which is it's pretty much up to date, because there wasn't much since then except for neutrokine. The early cases in the Board, they're all in one Board of Appeal, which I was lucky enough to be a member of. I'm not at the moment a member of another biotech board. They tend to do more early stage cases. We tend to get more downstream, closer to the market biotech cases, second medical uses, things like that. There was no policy, that's for sure. We didn't just sit down and say we're going to get tough on these early research cases. There was nothing like that. But I do recall the then chairman of the board saying, couldn't we use industrial application to stop too much early stage research monopoly? It was somebody's idea, there's no doubt about that, and a good idea in my view. It was certainly an interesting period to be involved in judging these appeals. Let me mention a few of these early cases just so you get the flavour. T870 of 2004. I ought to explain, if you don't know, that the dates on Board of Appeal decisions are unlike law report dates, the dates when appeals were filed. So a 2004 case. It's not decided in 2004. It's probably decided in 2006 or 2007, if they were lucky. T870 of 2004. The board said that the polypeptide in question could be made and used as a further research tool, in addition to the many other tools available in the art, for exploring the complex signal transduction pathways, etc., in the regulation of cellular processes and possibly disease states. But the whole burden is left to the reader to guess or find a way to exploit it in industry by carrying out work in search for some practical application geared to financial gain. You note those words. At this point, the boards were still talking about financial gain. That's back to the, the cosmetics and the beauty parlour approach. Geared to some financial gain without any confidence that any practical application exists. In the board's judgment, although the present application describes a polypeptide and means and methods of making it and prospective uses, it identifies no practical way of exploiting it in at least one field of industrial activity. And again, we're still talking about having to show one field of activity, the caveman and the transport. The purpose of granting a patent is not to reserve an unexplored field of research for an applicant. In the present case, the only practical use suggested is to use what is claimed to find out more about the natural functions of what is claimed itself. This is not in itself an industrial application, but rather research undertaken for its own sake, or the mere hope that some useful application will be identified. So the point I'd like you to take from that one is the commercial gain point. And the research program. The commercial gain, now, in T895 of 2005, this was the first of these cases that I was a member for, we were somewhat bothered by this commercial gain idea. If you have, sooner or later, someone was going to say, well, if you can't make a profit, that's the criterion. And so we decided to say, well, it's not just a question of making a profit in the classic sense, to show you've made more than you've lost. We should simply show that it's profit in the more general sense of some benefit. Now, the result was probably no better, because the result we came up with was the need to have what was called an immediate concrete benefit, which now makes me shudder almost as much as the idea of making a profit in the financial sense. Concrete, I should explain, is used particularly in German and possibly in French, the other official languages of the EPO, far more figuratively than it is in English. A German will say, concrete, what I mean is, to give you a straightforward example. Now, not that there were any German members of that particular board, but that's what we came up with. And as I say, I'm not particularly proud of it, but it's what an Englishman, an Italian, and a Catalan arrived at. More, perhaps as interestingly, that case, the zymogenetics case, said for the first time that I can recall that it was all right if all the evidence of what had been produced was work which had been done in silico and not in vivo or in vitro. That was not per se a problem, which rather it opened the field to the whole idea of bioinformatics. And it also said that the test for industrial application in the case of biotech is still the sufficiency test, and that again was borrowing from the earlier cases. T1452 of 2003, now despite the date it was a later case, just taken longer to work through the system. This was a case, this was an ex parte case where the application had been refused, and it was another of these cases where all that you could seem to do with the molecule in question was simply use it for further research. I remember it's quite interesting because when, instead of like the normal situation where you would sit down in the hearing room and a couple of patent attorneys would come in accompanied by their their technical advisors, who would typically be, chaps from the R&D department with tousled hair and biros in their pockets. They came in with a team, 3 or 4 very nattily dressed gentlemen, Gucci suits and sharp haircuts. They brought the marketing team along. And they gave us a fascinating insight into what happens in the market. They explained all about the idea of research targets. There is a market just in research targets. You can simply find something which looks promising and that you can sell. And therefore they said, you should allow us to do this. You should, because we can show you, we can demonstrate to you that we trade in things which have reached this stage of development, this early stage of development. And the problem was, having sort of been slightly surprised and interested, I have to say, in this lecture in modern pharmaceutical economics, we then said, yeah, but just what does it do? And of course, the Gucci suits couldn't answer that one. The chaps with the tousled hair might have been able to. But anyway, it was an interesting experience. And again, the result was much the same. I quote briefly, a basic principle of the patent system is exclusive rights can be granted in exchange for full disclosure of the invention, which includes the need to exploit how to exploit the invention. This must have a sound and concrete technical basis. That concrete word comes back to haunt me. As a speculative indication of possible objectives that might or not be achievable by carrying out further research with the tools described is not sufficient for industrial applicability. You get the picture, I think. Do I need to? I'll give you one more case from the old stuff. It's actually not cited in Nutrikine because it came after its decision of February 2009. And I think it was actually published later than both the first instance decisions in Nutrikine. But it summarizes the case law and the criteria for industrial applicability in the biotech context. And I think I've actually listed the points on the handout. The existing law, the case law establishes the criteria to be fulfilled. The information the application is filed should make plausible, that's something that we'll see again, the identity of the claimed compound. Thus, the compound may be attributed to a known family of molecules on the basis of a comparison between its primary structure and that of molecules known in the art. Then its putative functions must be disclosed. Experimental evidence is not necessarily needed. A number of reasonable assumptions may be made by taking into account the known functions of other family members, as well as, for example, not exclusively, by taking into account the distribution of the claimed compound in the body. It should also be clear that the treatments therein mentioned are in relation to the function plausibly attributed to the molecule. Post-published evidence backing up these assumptions is always welcome. In fact, the more information, the better, and the quality of the information is also fundamental. As often repeated, and then of course you get what every lawyer always says, each case must be evaluated on its own merits. But there are several expressions there which we'll see coming up in the Nutrikine litigation, to which I shall now turn. There are a large number of decisions in this litigation, but basically Eli Lilly started attacks on the patent of human genome sciences, both in front of the Boards of Appeal in Munich and in the courts, in the Patents Court in England. And in June 2008, the opposition division, which is the first instance in our system, revoked the patent for added matter and for lack of inventive step, which in England is called obviousness. They did not revoke it for lack of industrial application, although that was a pleaded ground of opposition. Less than 2 months later, the Patents Court, Mr. Justice Kitchen, as he then was, revoked the patent for lack of industrial application, insufficiency, and obviousness, which is what we call lack of inventive step. So you've got the patent revoked twice. I mean, you can't revoke a patent twice, but the written decision of the opposition division hadn't been issued. So in theory, and of course it could be appeals, which would suspend the decision. So you had 2 decisions saying the patent was bad, but only one for lack of industrial application. And then both parties appealed. In both cases, HGS appealed. And now I interrupt my story simply to tell you a little anecdote. The question is, who would deal with this case first? Because if the Court of Appeal in London dealt with it first and then decided one way, and the Board of Appeal in Munich decided the other, then it would be, well, A, unfortunate, and B, you might have a patent surviving on the face of it in one country but not in the rest of Europe. Whereas if the Board of Appeal went first and upheld the revocation, then not only would it be over and done forever, but the Court of Appeal wouldn't have to deal with it at all. And so, well, actually, we didn't even know about, well, we knew about the English litigation. I'm not sure the English court knew about the EPO litigation, but we didn't know we were getting the same case because it was only filed in 2009, and this was in 2009. We had an email from Lord Justice Jacob, as he then was, asking if we could speed things up and go first. Well, we can speed things up. We have the power to do that. But the problem is we can't make people do it in less time than the rules allow. We have no power to abridge time limits. And the time limits in appeal proceedings are extremely generous. Each party has 4 months to file his written case. But we said we would try, and we wrote to the parties. And the opponent said, yeah, I don't mind. I mean, he'd won anyway. And the patentee said, well, no, I'm going to have my 4 months, which is fine. He was entitled to it. It was a pity, but there we are. So we wrote back to Lord Justice Jacob and said, well, I'm sorry, they won't. You know, we can't do it. We'd thought we might be able to get it on by June 2010, but we can't because one party won't agree. And the answer to that was, can't you have another bash? That's a quote. And I was sitting there in Munich, sort of chewing my pencil and scratching my head and thinking, how can I explain again that we just can't make them go any faster? When we received another email which says, don't worry, I'm going to have a bash. And that's the point at which I realized bash was a word of the judicial vocabulary I hadn't really absorbed until then. Anyway, he summoned the parties in London into his court and tore them off a strip. But unfortunately, he couldn't make them go any faster in Munich either. He was rather almost unfairly critical of the poor representative who had said to us that he insisted on his 4 months. But he put back his case so that we still went first. Anyway, back to the story proper. In October of 2009, it's a decision we issued in December 2009, the Board of Appeal, the same Italian, Catalan, English team I mentioned earlier, upheld the appeal and said it was industrially applicable and it was also sufficient and inventive. So to the extent that we dealt with the opposition division's decision, we overruled them, but we also said it was industrially applicable. And the point I would stress is that this was the first time that anybody in the EPO had upheld industrial applicability. The opposition division didn't deal with it because they sent it down on inventive step. And we had to, because we knew what the Patents Court in England had said, and we knew that industrial applicability had to be dealt with, and we invited the parties in their written submissions to include their case on industrial applicability, which by agreement they did. It's very rare that parties agree to anything unless they're put to the sword. But anyway, so we heard, as a first instance and appellate court, industrial applicability for once and for all. And of course we allowed new submissions and, to the extent they wanted it, new evidence on the issue of industrial applicability. We allowed that into the proceedings, which we wouldn't normally do in an appeal. Then in February of 2010, the Court of Appeal duly upheld the Patents Court. So they stayed on the negative side and said there was a lack of industrial application and it was insufficient and obvious. And our old friend of the previous year, Lord Justice Jacob, as he then was, made really a lot of criticism in their judgment of the fact that we had allowed extra evidence in to deal with this case of industrial applicability. I'm not quite sure why he never realised that we only allowed it in because he insisted we go first and we wanted to get the whole case dealt with at one shot. But there we are. He commented on the difference between the two systems, and that's fair enough. There are differences. But at the end of the day, we decided one way and they decided the other. And then, as you all know, in November of 2011, it went to the Supreme Court, who overruled the Court of Appeal and held it was industrially applicable and, in part, sufficient, and did so, they said, following our jurisprudence, which was very gratifying. Mr. Justice Kitchen, as he then was, had gone through our jurisprudence at some length and said he was following it and saying it wasn't industrially applicable. The Supreme Court said that he had, with the greatest respect, got it slightly wrong, and that if you followed our jurisprudence, you came to the conclusion that it was industrially applicable. Let's look briefly at what the actual reasons of the Supreme Court. It's paragraphs 107 to 111, I'm not going to read it all, of the judgment of Lord Neuberger, where he summarises what he says is our jurisprudence in a mere 15 propositions or requirements. This is a long way from the is it obvious or not, which is where industrial applicability began. But he groups his 15 points into three general categories. The general principles: patent must disclose a practical application, a concrete benefit. I wince whenever I see concrete. Mustn't be speculative. You can use common general knowledge to supplement what's in the patent. And then secondly, if a patent discloses a new protein, which is usually the case, must disclose a real as opposed to a purely theoretical possibility of exploitation. Doesn't matter, as we said in zymogenetics, doesn't matter if there's no wet lab evidence, in silico will do. A plausible or reasonably credible claimed use will suffice. The requirements of a plausible possibility of exploitation can be at the biochemical, cellular, or biological level. That's also in zymogenetics. So all those points from our jurisprudence about where you have a new protein, and then a further 4 or 5 where the protein is said to be a member, as is the case in Nutrikine, said to be a member of a family or superfamily. And to complete the story, the case was then remitted back to the Board of Appeal because the Supreme Court, the Court of Appeal, hadn't dealt with a couple of sufficiency points which had arisen from the Patents Court judgment. The Court of Appeal then actually held that those claims were sufficient, and it included 2 composition claims. And I mention that en passant because when we come to some of the points that have been made about Nutrikine, that will be relevant. I'm conscious I probably used up my allotted time. Is it all right if I go on? I don't see any protests, so I will charge on. So Nutrikine in the Supreme Court claimed, or said it was following our jurisprudence. Boards of Appeal sitting in the middle of Europe in a somewhat cloistered environment are always very pleased when a national court says it agrees with anything that we've said. And you feel quite smug if a national court says nice things about the Boards of Appeal, when the highest national court in the land says something nice about not just one of your cases, but a whole line of jurisprudence. And when you're one of the 3 members that's been involved in the very case they say they're following, you feel very, very smug indeed. Which is why I now turn to the criticism that's been made of Nutrikine, both our case and the Supreme Court case. I have to say I'm not going to deal with all the commentary that's on Nutrikine because time doesn't allow, because I don't know it all. I'm just going to take two appraisals which have actually crossed my desk in journals that I get anyway. I'm afraid if you came expecting some scholarly review, I'm going to disappoint you. Firstly, there was an article in late 2012 in EIPR by 2 gentlemen called Minson and Nielsen, industrial application requirement for biotech inventions in the light of recent EPO UK case law, a plausible approach or a mere hunting license. Hunting license, I think, comes from an American case where the test is not industrial applicability, what they call utility. And rather the same as us, saying, we're not going to give you patents for research programs. The American court said we're not going to give you a hunting license just to go and keep looking for more possible uses for what you've got so far. I confess I'd not heard of Messrs. Minson and Nilsson, though to judge from the footnotes of this article, if you subscribe to various Scandinavian law journals, you might have. They call the Supreme Court decision in Nutrikine groundbreaking, which I think I take as a compliment, or the new Supreme Court should take as a compliment. They say that both the sufficiency and industrial application criteria have been tightened up as a result of these decisions, which I frankly don't understand very much. Because I think, if anything, most people would say that what we in Nutrikine, the Supreme Court in Nutrikine, did was make it easier to get patents. But they do make the interesting point, and I think I do agree with them on this, that although if you lower the hurdle of industrial applicability and possibly of sufficiency in order to get a patent through the door, as it were, you probably make it harder to satisfy the requirement of inventive step. Because you're actually you're in effect saying everybody can understand what's happening at a much earlier stage than traditionally. So therefore, to actually show that there's something truly new over the prior art and truly inventive over the prior art is going to be harder. It's at the very end of their article, and it's speculation, but I think that could be interesting. The other appraisal I've read is by a lady called Amanda Odell West at Manchester University, who I have heard of. And she published this later, late 2013, with the interesting title, Has the Commodore Steered the Fleet Onto the Rocks? It's a reference back to the activist case I mentioned at the outset. She says this: although the patent was eventually maintained, this is the abstract, patent eventually maintained in both jurisdictions, the Supreme Court overlooked Court of Justice jurisprudence concerning the standard for industrial application under the Biotechnology Directive, and instead followed inconsistent EPO jurisprudence, for example, admitting post-published evidence, even though the Boards of Appeal are not themselves so bound. The result is doctrinally muddled sliding scale standard for inventions arising in biotechnology. The ramification of a patent policy that supports early research inventions in biotechnology necessitates the standard for industrial applicability be brought into line with that set by the CJEU in Monsanto and a consistent jurisprudence at the EPO established. She doesn't like it. Anyway, I'm going, if I may, just to look at some of her criticisms and tell you what I think of them. She has a bunch of comments really on what you might call the evidential points, that we didn't pay enough attention to what is called boilerplate, that we allowed post-publish evidence, and that we accept plausibility of some industrial use or some use. I think nobody pretends that any of these biotech cases that someone's going to go out the door and immediately, as they said in 606/96, open a manufacturing plant. Let me deal first of all with plausibility. Mrs. Odell West says this is the language of inventive step and we shouldn't be transporting that into industrial applicability. Well, it is indeed the language of inventive step. If you can in your patent application show that you have plausibly performed something inventive over the prior art, then that is in itself, in theory, sufficient. It shouldn't be the case, she says, for plausibility. I'm not so sure. I really don't see why we can't use the same language or the same concept in two contexts. At the risk of being naive, if you go back to my caveman example, when he showed that the first wheel could be used on a cart, and he'd have thereby invented the cart, I think he would have satisfied both inventive step and industrial application. And in principle, I don't see why that shouldn't be the case everywhere. The post-published evidence point is trickier. The rules in our system are clear. You can't have post-published evidence for novelty for obvious reasons, but you can for inventive step if the patent application itself disclosed something that was at least plausible. So you can use post-published evidence as support, but not as actual basis. You shouldn't be allowed to do that, she says, in the case of industrial applicability. And I have to say I see some force in that as a matter of principle. Rule 42, you recall, says you must state the industrial applicability if it's not obvious, and if it's obvious, that suggests that it must be clear ab initio. Having said that, I think our case law has developed in a way which really says that it's otherwise for biotech. I think we have to accept that we have a biotech industrial applicability case law and a classic industrial applicability case law, and that one has to accept that one is at least a subspecies of the other and not just a complete homogeneous collection. After some hesitation, I can accept that we should possibly allow post-published evidence for biotech cases, but it's a point we could discuss after. Now then we come to the boilerplate. Now this, I'm on slightly firmer ground here, but possibly because I have something akin to insider knowledge. Boilerplate was actually a term coined not, Lord Neuberger said we used it. In fact, it was used by one of the parties in the Nutrikine case in the hearing before us. It's more commonly called this long list of possible diseases, which was recited in the Patents Court in Nutrikine here. It's more usually called a laundry list, because it's just like, it's almost the same every time. It's like the list you get on the back of the door in the hotel wardrobe. Let me just take you back to what Lord Neuberger said, which I read briefly at the beginning. I won't read it all again, but referring back to what the Patents Court had said, the description of the patent is confusing, long and diffuse, widely expressed, contains extravagant and sometimes contradictory claims. Rather more tolerantly, the Board of Appeal referred to the patent as being drafted on a boilerplate basis. Then let me take you back to what David Kitchen said in the court, in the Patents Court here. He said, talking about this long list of cases, yeah, it's pretty boring, I know. In this case, I'm quite satisfied the skilled person will consider the patent does not of itself identify any industrial application other than by way of speculation. It contains an astonishing range of diseases and conditions which Nutrikine A and its antibodies may be used to diagnose and treat, and there is no data of any kind to support the claims made. The skilled person will consider it totally far-fetched that Nutrikine alpha could be used in relation to them all, and as I've found, will be driven to the conclusion that the authors had no clear idea what the activities of the protein were, and so included every possibility. To have included such a range of applications was no better than to have included none at all. And that was, in my view, fair comment, because there was absolutely no evidence whatsoever. Now, we've seen that the Supreme Court came to a different decision, and they did so based on our jurisprudence, which we say had developed to the point where plausibility, etc., would be okay. But now let me take you, if I may, to paragraph 27 of our decision in Nutrikine on the subject of boilerplate. Filing patents with such long lists of conditions and activities, and subsequently relying on the few which have been confirmed or demonstrated, is what the respondent, as the opponent, Lilly, criticised as a boilerplate and cherry-picking practice. We made no comment about the mixed metaphors. It can certainly be argued whether or not such a practice is proper, but it is significant that the respondent, Lilly, acknowledged, albeit in the form of criticism of the patentee, that it is a practice used by patentees, and the appellant pointed to the respondent's own US document number so-and-so as an example of just such a laundry list. Thus, the skilled person is acquainted with this practice and able to differentiate mere boilerplate from positive technical information. In the present case, the description of the patent delivers sufficient technical information, namely the effect of neutrokine alpha on T cells and the tissue distribution of neutrokine alpha mRNA, to satisfy the requirement to disclose in the nature and purpose of the invention and how it can be used in industrial practice. Now, that is a reference to what actually happened in the case we had. When we were towards the end of day one of the appeal in Munich, in the neutrokine alpha case, the opponents, respondents to the appeal, who'd won below, made the submission that what the patentee had done in this case was called a worst example of the practice of including what was called boilerplate when you file an early stage application, and then at a later stage, cherry picking the bits you want. Well, it doesn't work for curing the common cold, it doesn't work for cancer, but it does work for tissue rejection after a transplant. And those weren't examples, but this is what they were saying. Boilerplate followed by cherry picking. And I remember thinking, this is a bit odd. Why are they making this submission? And I look aside, see the Italian and the Catalan were having a similar reaction. And I remember saying, is this your submission, that this is normal patent drafting practice? To put in these long lists? Yeah, that's my submission. And I thought, this is the turning point of this case. Every case has a turning point, and this was the turning point of this case. And what was interesting was that the people representing Lilly, both parties actually before us, were not the same teams, not the same actual persons who represented them in the English cases. But Lilly had the chap who represented the English case sitting in the row behind. And I could see when this conversation began that his head went down, and by the time I'd had the conversation, it was like this. And he knew it was a turning point as well. Now, the article by Amanda Odell West says this at page 295. Counsel for Eli Lilly, this is in the Supreme Court, submitted that the wordy and extravagant claims should count against human genome sciences as a matter of policy, a point which the Supreme Court said had some attraction. But as the patent was not actually so confusing that it diverted the person skilled in the art from being able to understand the teaching, the point fell flat. This cannot be a correct statement of principle. It's untenable that the policy for disclosure in patent law should be negatively directed to avoiding actual diversion of the skilled addressee, rather than positively teaching how to perform the invention. It's further evidence that the Supreme Court judgment, based heavily on the Board of Appeal in HGS, swings too far in favour of the call for early patenting in biotechnology, etc., etc., etc. What the Supreme Court actually said, if I can find, paragraph 92 of Lord Neuberger, it's unlikely that the Board of Appeal and Mr. Justice Kitchen received very different arguments in the present case. Well, of course, Lilly didn't tell them, did they? In the light of the reasoning in the two decisions, and the fact that the parties in the two sets of proceedings were the same, it is less clear how similar the evidence before each tribunal was. The witnesses were different, and there was at least one further expert witness on behalf of the patentee before the board, which post-dated the Patents Court judgment, and there was no cross-examination. And then he makes the comment which is referred to in the Odell West article, counsel for Lilly's submission that the extravagant and wordy claims of the specification should count against HGS as a matter of policy has some attraction. However, I refer to the board's comments at paragraph 27, that's the one I read you just now, where we actually say they referred to the boilerplate and said we all do it. The drafting of a patent is a ticklish business. No doubt, particularly in some types of case of which biological patents may well be an example, not least because it's a fast-developing field with substantial commercial and scientific pressures. Anyway, so I think on the boilerplate, I've taken some time and perhaps laboured it too much, but it was clearly Lilly who said boilerplate is every day. And that's why we said then the skilled person will know it's every day. The next criticism, there's only two more, and the last one's fairly quick. The next criticism is that we, the Boards of Appeal, because our real target is the Boards of Appeal, the Supreme Court were just wrong to follow us, have conflated the rules on industrial applicability and the rules on sufficiency. I'm prepared to plead guilty in part to that. I wouldn't say we've conflated them, but we've certainly, and I've already told you this, we've actually said the same test applies, but that was in the classic industrial applicability case law anyway. On the other hand, I think the lady is also in part guilty too. I think she's looking at, she borrowed the Commodore's telescope and is looking at the case through the wrong end. She says you want the classic sufficiency test whenever you have possible medical or therapeutic uses of a compound. And it's not enough. And that's right. I mean, our case law says quite clearly, if you're claiming what's called a medical use of a compound, not just the compound itself, you have to show that you teach the sufficiency of the therapy which the compound will be used for. That I think we can all accept. You have to show it'll work in therapy. But in this case, neither we nor the Supreme Court were looking at anything like that. We were looking, and it has to be admitted, at some sort of higher level invention than an actual therapeutic application. And the case law, I suggest, had developed to the point where that was, in certain circumstances, exceptional, particularly where you had plausible suggestion based on membership of the same family as an earlier invention. We did, admittedly, in the passage of our decision dealing with sufficiency, which we dealt with before industrial applicability, point forwards to a later passage on industrial applicability, which is where we said that the boilerplate thing would be worked around by the skilled person. And I think possibly that was a mistake of drafting, and if we'd done it the other way, it would have made it clearer. But I don't think we actually went so far as to conflate the two principles entirely. And I remind you, there is no use or therapeutic use claim in this patent. There were two composition claims, but only composition claims, and they were actually the claims that went back to the Court of Appeal and were allowed as a matter of sufficiency after the Supreme Court. So I think we're guilty of bad drafting, but I don't think we're guilty of conflating two things. But there we are. And then lastly, and perhaps most importantly, sorry, there are two more. There's the Monsanto point. It said that the Supreme Court should have followed the Court of Justice in Monsanto rather than the Boards of Appeal. I'm afraid I think I understand it, but if I understand it, it seems to me to be a very naive point. The Court of Justice in Monsanto, you know the Monsanto case. This is where the soy meal imported from Argentina was made from what was called a Roundup Ready plant, which Monsanto had patented in various European jurisdictions, but not in Argentina. So this stuff was grown in Argentina, turned into meal, and then imported into Europe. And Monsanto sued the importer in Holland. And the argument, or the point which went to the Court of Justice was, but the meal, the active, protein, was not actually active then. It wasn't doing anything in the meal. It was dead. But it could have worked earlier in the plant, and it could possibly work later if it was implanted into some other material. But it wasn't actually working there. And the Court of Justice said, well, that's not covered by the scope of protection of the patent under the Biotechnology Directive. That seems to me to be an infringement point. I'm not sure what difference that how that affects how you decide whether something is industrially applicable for the purpose of granting or maintaining a patent. And I'm also not sure how that really relates at all, because all that comes out of the Biotech Directive in that respect, as regards industrial applicability, is Article 5.3, I think, which is in exactly the same terms as Rule 29.3 of the EPC, which indeed borrowed it. It borrowed the directive in several respects, lock, stock and barrel, and says the directive shall be used for the interpretation of the rules it borrowed from the directive. I'm afraid I don't really get it. I think if you go from Article 5.3 of the directive to Article 29.3 of the EPC, it just brings you back into the industrial application argument, which we interpret according to our case law. Now, I've skimmed over that, and if somebody, I think I see one or two puzzled looks in the front row, so I'll happily, oh good, well that's all right. Okay, and the very last point is that the Supreme Court should not have followed the Boards of Appeal for two reasons, as I see it. Firstly, because the Boards of Appeal do not even follow themselves. And secondly, because the Board of Appeal's jurisprudence was not, contrary to what the Supreme Court said, established. I've got three comments on that. Firstly, well, no, we don't follow our own decisions. We don't have a system of precedent, like in England, for example. But strangely, we do allow ourselves to be influenced by earlier decisions, and we say if we disagree with one or more of them, and if we do disagree with one or more of them, there's a device called a referral to the enlarged Board of Appeal, which then says which is correct or what the law should be. And that's not so far removed from, for practical purposes, bearing that every case is decided its own facts, from having a system of precedent. And I just add as a footnote, while the House of Lords has now become the Supreme Court, I assume that the old House of Lords principle of not being bound by its own decisions if it doesn't want to applies. I remember it was back in my Cambridge days, I think, that the House of Lords made that announcement. I remember one of my tutors at the time saying they should have done it in a case, but what do? They had a press conference. But anyway, the fact is they decided they wouldn't be bound by their own decisions. And it seems to me that the Boards of Appeal are simply doing the same. I mean, as Mr. Justice Jacob, as he then was, said, we are the House of Lords and the Bundesgerichtshof and the Court of Cassation if we are the last appeal. Well,
but you don't usually say you're deviating from established jurisprudence.
No, we very rarely deviate from it in my view.
Okay.
Well, but yes, I'll come back if I may. Well, that's my second point, really. I can see there's an interesting debate coming up later. No, our jurisprudence is not established in the sense that it's set in stone, and it has in fact developed. In fact, if you look at G308, which has nothing to do with biotech, but which is the enlarged board decision on the referral on computer-related inventions, which was actually held inadmissible, I just read you from the headnote. As development of the law is an essential aspect of its application, whatever method of interpretation is applied, and is therefore inherent in all judicial activity. Legal development as such cannot in its own form the basis of a referral to the enlarged board, only because case law in new legal and or technical fields does not always develop in linear fashion, and early approaches may be abandoned or modified. And my last comment is that if this is right, if we didn't have an established jurisprudence, and if the House of Lords should not have followed it, the Supreme Court, I'm showing my age, it's the Supreme Court, then what about Lensing, and what about activists, and what about Genentech, and what about Merrill Dow and Norton, and all the other cases in which not just some national courts, but the national courts here have said that one should follow the Board of Appeal unless there is a good reason not to do so. Mrs. Odell West says that we've now fulfilled the proviso to the principal and activists, and that we've actually, as the Commodore, led one of the ships onto the rocks. My only problem is that I'm not really sure what the rocks are. Thank you.